And there's something coming through there.
Explain that these kids
All right, this is the case. What is the first case? Be here today. What's the style of the statute? While I'm looking for it. Looks like Ada Wells administrates for the estate of Dr. Samuel versus American Life Insurance. Is that right? Who represents the plaintiff?
We do, Your Honor.
Are you all ready to proceed?
Yes, Your Honor. And at this time, Your Honor, we would like that all non-party witnesses be sequestered.
All right. Well, I'll do that as soon as I determine that we're ready to proceed.
All right.
I take it you're calling for the rule.
Yes,
You
sir.
separate the witness. All right. You all represent the defendant, I take it.
Yes, sir.
And are you all ready to proceed?
Yes, sir.
All right. Would you, would all the parties and all their witnesses please stand?
We'd like to object
What is that?
on the grounds that this is a mock learning experience, that we feel our witnesses know the testimony inside and out either way. So there's just no sense in making them believe when they could be learned in the courtroom.
What about them?
Well, Your Honor, they've been through this a lot of times, so there would not be a learning experience, so I feel that they should be sequestered.
Okay, well, I'm going to separate the witnesses. Okay, you all want to have your parties and the witnesses stand. All right, got it? All right, all of you want to raise your right hands, please. Each of you solemnly swear that the testimony you're about to give in this case will be the truth and nothing but the truth, so help me God? All right, now you all have to go up except for the parties. All the non-party witnesses will need to go with the sheriff, and he'll show you a room where you can wait until you're called. All right, is this our jury over here? Are you all the jury?
Yes.
Okay. Would each of you all please raise your right hand? Each of you solemnly swear that you will truthfully answer the questions asked you concerning your qualifications to serve as jurors in this case.
Yes.
As you all may or may not know, the first step in any case is to qualify the jury. I'm not sure exactly how much latitude we'll have, but let me ask the jurors whether any of you all are related by blood or marriage to Adele Wells, plaintiff in this case. All right, any of you good friends of her? Visit with her socialists? Would the attorneys for the plaintiff please stand? All right, now would y'all introduce yourselves, please?
I'm Oliver Coulter.
Please?
Oliver Coulter.
I'm Alex Wyman.
All right, now are any of you related by blood or marriage to any of these lawyers? Okay. You may sit down. Now, would the attorneys for the defendant please stand? All right, would you all introduce yourselves?
My name is Tim James, and this is my distinguished co-counsel, John Rattle, Teresa Staff, and Marshall Stewart.
You'd introduce yourselves to the jury, too. Now, are any of y'all related by blood or marriage to any of these attorneys? All right, y'all may sit down. Now, let me also ask, if any of you all, any of the jurors, heard this case discussed, or have any previous notion about what the case is about? I take it by your silence that you don't. Either that or you're not telling the truth. In any event, we'll have to go by what you all tell us. Would the counsel for the plaintiff wish to ask the jurors any questions?
No, Your Honor.
Counsel for the defendant?
No, Your Honor.
You all accept the jury? All right, ladies and gentlemen, we will now proceed with the case. And I would ask that the attorneys for the plaintiff, they would now please make an opening statement.
Yes, Your Honor. May it please the court, counsel, members of the jury, I am Amy Lindsay, my colleagues, Jennifer Edwards, Alex Morrow, and Oliver Coulter. We represent the plaintiff in this case, Ms. Adele Wells, who is acting administratrix of the estate of her late husband, Dr. Sam Wells. Ladies and gentlemen of the jury, this is the part of the trial which we refer to as an opening statement. In this, counsel for the defense and I are allowed to give you a brief synopsis of the facts which we will present. And in doing this, help point out to you what we feel the facts show. After we are done presenting our case, counsels from both sides will then give you a closing statement. You would then be asked to reach a verdict. This is a case which involves Mrs. Wells and the American Life Insurance Company, wherein Mrs. Wells was denied payment of her late husband's insurance. Dr. Wells bought this policy in hopes of providing Mrs. Wells the worry-free life she was used to should he not be around. But this was a mistake, because when Dr. Wells died unexpectedly, leaving no will, Mrs. Wells was made administratrix of the estate of Dr. Wells. And then, when she brought the policy to the American Life Insurance Company, they refused to pay her. Mrs. Wells was now faced with all the problems that she had never had to worry about before. Ladies and gentlemen of the jury, in this case you'll be asked to decide whether Dr. Wells died of an accident or of suicide, and the amount of insurance Mrs. Wells is entitled to. We are confident that you, with your good sense of justice, will find that Dr. Wells did in fact die of an accident and award Mrs. Wells the full amount of her late husband's insurance, and a total of $100,000. Testimony of our witnesses will show that Dr. Wells was a good-natured and moral man, a man much respected in his community, and a loving husband of 24 years. A man who had always protected his wife and kept her from having to worry over money matters. A man who would not have killed himself in his library for his wife to find his dead body, leaving her with unsettled finances and no one to provide for her. What really happened on the morning of February 12th was something like this. When Mrs. Wells came downstairs, Dr. Wells was drinking coffee. He was in his usual good spirits, and after a brief conversation, he went to the library to prepare for a hunting trip that day. Mrs. Wells then left to take a friend to work, and Dr. Wells began to clean his gun. When he was dismantling the gun, in order that he may clean the inside, the gun accidentally discharged and killed him. When Mrs. Wells returned home, she called for her husband, and on receiving no answer, she entered the library and found her husband dead of a shotgun wound. She then called Deputy Sheriff Clarence Williams, who in turn called the Assistant County Coroner, and they came and investigated the scene and issued a certificate of death which stated that Dr. Wells died of an accident. The defense would have you believe that Dr. Wells committed suicide because he was being investigated by the IRS. But we will show that the meeting to determine if he owed any money at all wasn't scheduled until 3 days after his death. We will also show that Dr. Wells wasn't in as bad financial condition as the defense would have you believe. He still had $1,700 left in the bank and $30,000 in equity on his home. We now ask that you review the facts that we present to you in this case, and at the end of the trial comes the only just conclusion, which is that Dr. Wells did in fact die of an accident. We now leave the fate of Adele Wells in your capable hands. Thank you.
Would y'all like to make an opening statement on behalf of the defendant?
Yes.
May I proceed?
Please, the court, attorneys for plaintiffs, and ladies and gentlemen of the jury. My name is Tim James, and I, along with my distinguished co-counsel, John Ratliff, Teresa Steff, and Marcia Stewart, represent the defendants in this trial, the American Life Insurance Company. Now, you have heard what the plaintiffs will try to prove here today. We plan to prove something entirely different. Dr. Samuel Wells took his own life. Because of that suicide, Mrs. Wells is not entitled to the money she's asking for today. Now let's get one thing straight from the beginning. We're not here to dishonor the memory of Sam Wells. He was a good man. Like all of us, he was human. His reputation is not on trial here today. We are here to decide if he died of an accident or a suicide. Now please remember during the course of this trial that this is a contract action. November of 1984, Wells purchased a policy from the American Life Insurance Company. Of course, this is the one in question here today. It is a legal binding contract. If the plaintiffs meet their due proof that this was an accident, will gladly pay double indemnity. We feel, however, that this was a suicide. We prove that Dr. Wells was a man deeply troubled by financial problems, so deep in fact that they led to the taking of his own life. And one of the first things that will become clear to you as jury members is that Wells was an expert hunter, a man who knew gun safety inside and out. And even think this an accident is ridiculous. We will establish for you, jury members in court, a series of events over a period of 7 months, starting in August of 1984. Wells purchased 1,000 shares of Guess Oil Company, $20 a share. Highly speculative purchase. His reason? To make money fast. Also in that month of August, the Internal Revenue Service began an investigation of Dr. Wells, who for the entire year 1983 and the first half of 84 failed to declare cash fee payments. Just 1 year before, 1982, he listed cash fee payments in excess of $15,000. A drastic change. His account, he owed back taxes of up to $10,000. Now, Wells found out about this investigation in September. IRS agent contacted him about the money, told Wells to take care of the matter. Now, just for a little change of plot here, we come to October, late October of 84. Wells signed an application on a 5-year life insurance policy, term policy. In November, he paid the premiums on that valid contract, of course, this being the policy in question. Now in November, IRS once again contacted Dr. Wells and insisted on a meeting. Wells, for some reason, had not got in touch with them. Wells was hesitant to schedule a meeting, but finally a date was set, February 15, 1985. Now, if things hadn't been bad enough for Dr. Wells, they got worse in January. Guess Oil Company went bankrupt. Wells lost $20,000. Tried to borrow money from the bank. No go there. He was already heavily mortgaged. We'll prove February 11, just the day before his death, tried to borrow $6,000 on the American life insurance policy. But being term policy, it had no long value. Now we come to that fateful day of February 12, 1985, just 3 days before the scheduled IRS appointment. Mrs. Wells woke to find her husband not in bed. And we'll prove that at 9 a.m., Wells called Norman Crowe, his last chance. He needed $6,000 by noon. Crowe could not meet his deadline. Dr. Wells hung up the phone to find his desk covered with stock, absolutely worthless. Between 9 and 9:30 a.m. on the 12th, Sam Wells chose the easy way out for himself and his wife. Sam Wells gave his wife the greatest gift he had, his life, in hopes that she might have financial security for the rest of hers. And now we come to the policy itself. The day before the death, no stray marks were present. Surprisingly, had 2 check marks beside 2 very different clauses. Suicide of insured and benefits in event of accidental death. We believe that Sam Wells contemplated and then carried out his own death. And we believe that once the jury, you've heard all the evidence, you will find for the defendants and award Miss Wells $650, the only amount she is legally entitled to. Thank you.
All right, who's the plaintiff calls and first witness?
Your Honor, plaintiff's called Deputy Sheriff Clarence Williams to the stand.
Take a stand over there behind the rail, please, in that orange chair.
Your Honor, at this time, all of this will be marked as plaintiff's exhibit A and B for identification. This will be used on examination.
You got it, Mark. The other Mark, please. Objection.
No objection, Your Honor.
Could you please state your name?
Deputy Sheriff Clarence Williams.
And what is your occupation?
I'm the Deputy Sheriff of Lexington, Kentucky.
And would you please tell the court of your job training?
I've attended Eastern Kentucky University in accident investigations. I've also attended an 8-week series which was a session of lectures and demonstrations sponsored by the University of Kentucky Medical School and also the Kentucky State Police.
Your Honor, I'd like the court to recognize Deputy Sheriff Clarence Williams as an expert in the field of accident investigation. All right. On February 12, 1985, would you please describe the series of events that occurred around 9:45?
Yes, I received a phone call from Mrs. Adele Wells.
And what did you do as a result of this call?
I proceeded over to the Assistant County Coroner's home and picked him up. And then I proceeded to the Wells home.
Do you recognize Plaintiff's Exhibit A?
Yes, this is the Wells home.
Okay. And on that day, after you entered the front door, would you please go through what you did that day?
Yes.
Would you please step over, please?
I entered the front door and saw Mrs. Wells and a friend sitting on the couch. They motioned to go in the library. When I went to the library, I saw Dr. Wells dead in his usual hunting clothes. I found a screwdriver beside his body and a shotgun also beside his body. I found some brain tissue on the wall and some stock certificates on the desk. I also found some cleaning material.
And did you conduct an investigation?
Yes, I did.
And based on your expert opinion in your investigation, what were the facts which led you to your conclusion?
As I said, I saw Dr. Wells in his usual hunting clothes. His screwdriver, his shotgun, tissue on the wall, stock certificates, and some cleaning material.
And in your expert opinion, what was the cause of death?
Accident.
Would you please sit? Now, I'd like this to be marked as Plaintiff's Exhibit C for identification.
You got it, Mark? Hey, counsel, folks.
Yes, all right.
Just suggest the gun this way is misleading, speculation. We feel that this is speculation. And that it is misleading to jury members. That all this classified these depositions was hot.
doctor's shotgun, were you familiar with it?
Yes, I was.
And what did you know about the gun?
I know the gun was faulty.
And how did you know it was faulty?
Well, one time I tried to fire it and it didn't discharge.
And would you please describe in detail how this incident occurred?
Well, I aimed the gun and I pulled the trigger and no bullet came out.
And are you positive that that was the doctor's gun?
Yes.
You stated earlier you were a friend of the doctor's. Could you please describe his friendship in more detail?
Yes, we went hunting a lot together. As a matter of fact, we had a hunting engagement that day.
And did you know him in any other respect besides hunting?
He and I were both ushers at the St. John's Episcopal Church.
And did he participate in any other social events or activities?
Yes, he was also on the school board.
Okay, and would you please describe the doctor's practice to your knowledge?
The doctor had a good practice and he had many patients.
And could you please tell us what was the doctor's reputation in the
The
community?
doctor was a very moral man.
Objection, Your Honor.
As he's saying, the jury would disregard that question. He's not qualified to give that opinion.
Now, would your friendship with the doctor in any way affect your expert opinion?
No, it wouldn't.
Okay. Your Honor, I'd like to offer plaintiffs exhibit A and B as evidence.
All right? That will be introduced.
That's all, Your Honor.
Examination?
Deputy Williams, how long have you known Dr. Wells?
For many years.
Where were you when Mrs. Wells phoned you on February the 12th, 1985?
I was at my house
Why were you phoned?
because I was off duty that day.
Well, why would she phone you if you were off duty?
She didn't know who else to phone.
She didn't know who else to phone. She could have phoned any other police officer. Why did she phone you particularly?
Well, I am a police officer and also the Wells family was a friend of mine.
What did Mrs. Wells tell you when she phoned you?
That the doctor was dead and that she wanted me to pick up the assistant county coroner.
Did she say anything else?
No, she didn't.
Deputy, I beg to differ with you. According to your deposition, you say that Mrs. Wells told you that Dr. Wells had died as a result of his hunting gun accidentally discharging.
Well, I said he got shot.
That is not what Mrs. Wells told you. Mrs. Wells told you that she said that the gun accidentally discharged. Is that true?
Yes.
Would it have been possible for you to be biased in your thinking that Dr. Wells' death was accidental?
No, it wouldn't.
Did you and Dr. Wells ever do anything together?
Yes, we did.
What did you do? Did you ever socially?
Yes. Well, we went hunting together.
In your opinion, was Dr. Wells an experienced hunter?
Yes, he was.
So Dr. Wells could safely and adequately clean a gun, is that correct?
Yes.
Now you're assuming that Dr. Wells was either cleaning or fixing his gun, is that correct?
Uh-huh.
What killed Dr. Wells?
A shotgun?
A gunshot wound to the head, correct? So the gun was obviously loaded.
Uh-huh.
Deputy, you're an experienced hunter. Does an experienced hunter ever point the barrel of a loaded gun in the vicinity of his body, much less his head?
Well, they try not to.
Did you pick up the gun?
Yes, I did.
Did you examine the gun?
Yes.
What did you find?
I found one discharged shell in the chamber.
Was the safety on?
I can't remember.
Is this illustration similar to the gun in question?
Yes, it is.
Could
Your
you-
Honor. Yes, you want to come around? Steve.
Okay. show the jury where the safety is located? Okay, get up. Right there. This little thing right here. This little thing right here is the safety. Right there. You say you examined the barrel of the gun, is that correct? Yes, I did. So in order for you to examine the barrel of the gun, you had to break it open, is that correct?
Uh-huh.
How could you break open the gun without noticing whether or not the safety was on? It was directly in front of you, is that correct?
That's correct.
Would an examination of the safety be a determining factor in your investigation?
Yes, probably would.
In fact, Deputy, wouldn't it almost prove the plaintiff's claim, if the safety were on, that Dr. Wells did die as a result of a tragic accident?
Almost.
What other items did you find
Well,
near the body?
I said I found a screwdriver and the shotgun. Also, his cap.
Deputy Williams, would the average man with the average arm length have the capacity with which to trigger a shotgun if it were pointed toward his head, as in such this, like this? The average man with the average arm length.
But how long would the shotgun barrel be?
Well, that's pure speculation. We're just saying the average man.
Probably not.
He would have to push back. He wouldn't be pulling trigger, he'd have to push.
Yes.
So he would have to reach an additional to push the trigger. Then would it be possible for a person to use a screwdriver to cause a gun to discharge?
Yes, it would be possible.
Deputy, in this drawing over here, the body is in front or behind the desk, in front of the desk. Chair's right here. Can you think of any reason why Dr. Wells would have been cleaning his gun over here, fixing his gun, whatever you're
Yes, I can. The doctor was going to clean his gun, so he got out his cleaning materials and his gun. He set the cleaning materials on his desk, and then he went over in front of the desk to dismantle the gun with the screwdriver and to clean it. He did not want to clean the gun on his desk because he wanted to get his stock certificates dirty.
Well, Deputy, it appears to me that it would have been much simpler for a man. How old is Dr. Wells?
Dr. Wells is 50.
And he's 6'2", right?
Mm-hmm.
So it appears to me that it would be much easier for him to be sitting in this chair cleaning his gun, being relaxed, than it would be to be over here on this side of the desk in an awkward position.
Well, as I said, he did not want to get his stock certificates dirty that were on his desk.
Deputy, you don't, those stock certificates were worthless. So can you think of any reason why he would worry about getting them dirty if they had no value?
Well, he wouldn't want to get his desk dirty along with it.
Deputy Williams,
Yes.
did you look for a suicide note?
Yes, I did.
Did you find a suicide note?
No, I didn't.
Why did you look for one?
Because usually, in most cases, if somebody's going to commit a suicide, they would leave a suicide note.
Deputy, most people who commit suicide, they're wanting to deceive an insurance company. Do not leave suicide notes. Does it make any difference to you whether or not Mrs. Wells gets the money?
Yes, it does.
How much difference does it make?
A lot.
How much?
Because a lot.
Could you please elaborate what you mean by a lot?
Well, she was a friend of mine. I want to see her happy.
Well, Deputy, could your relationship with the deceased have in any way clouded your professional opinion?
No, ma'am.
Thank you.
All right, do you have any redirect?
Yes, Your Honor.
Sheriff, just a minute ago, the defense counsel was talking about an average man. Do you know precisely what an average man is?
Yes,
Would you tell us?
around 5'8".
5'8"?
Yes.
And,
Objection, Your Honor.
Your Honor, this was brought up in their cross-examination, both Wells and yourself.
What is,
They're just speculating on this. He has no professionalism to determine how tall a man, an average man is.
you asked what, how tall an average man is?
I said I asked if he knew what an average man was, because that's what they brought up, what an average man was.
All right, I'll overrule it, you go ahead and answer it if you know.
5'8",
And did you say what the deputy, Dr. Wells' height was again?
6'2".
So, would you think you would need a screwdriver to push the trigger on his gun?
No.
Objection. It's purely speculation.
Overrule.
Now the barrel, is there any other reason a hunter would look down the barrel of the gun?
See if it was clean.
Is that possible, yes, John?
Yes.
Okay. And is it proper procedure to look for a suicide note when someone dies?
Objection. He's leaving the witness.
Sustained.
Okay. In a normal investigation, what would you do?
Well, I would investigate all of the facts in the room, and then I would check for any other things, such as a suicide note.
And just once again, would your professional decision in any way affect your personal?
No, it wouldn't.
That's all you want.
Any recall?
Yeah. Deputy Williams, you have told this court that it was proper procedure for you to look for a suicide note. Is that correct? Yes, it is. Well, it appears to me that it would be proper procedure for you to examine the safety on the gun. Is that correct? Yes. So you disregarded part of the standard procedure that you had been trained to use. Is that correct? Mm-hmm. Thank you.
Anything further?
Just one last question, Your Honor. Now, when you see somebody lying there dead, do you ever make mistakes on your investigation? Do you ever scared or such?
Sometimes.
Yeah, and would you forget things sometimes?
Yes.
That's all, Your Honor.
You may sit down.
Thank you.
Who do you call?
Your Honor, plan of cause to stand Dr. Daniel Cohen.
You were sworn to the other witness. Stay behind the stand over there. Speak up so the jury and I both can hear.
Sir, would you please give us your name? Daniel Cohen. What is your profession? I'm a physician and surgeon duly licensed to practice in Kentucky. I'm also the assistant county coroner, and I'm in general practice. How long have you been in general practice? 20 years. And how long have you served as assistant county coroner? 10 years. Where are your duties as assistant county coroner? To perform investigation and autopsies to find the cause of death, and to conclude our investigation, we issue a certificate of death. Your Honor, I would like the court to recognize Dr. Daniel Cohen as an expert witness.
Any objection? All right, see if it's so recognized.
What happened on the day of February 12, 1985? Dr. Wells died. And how did you find out that Dr. Wells had passed away? I got a call from Deputy Sheriff Clarence Williams. And what did you do as a result of this call? Well, the Deputy Sheriff came over and picked me up, and we proceeded to Miss Wells' house. What did you do when you arrived at the Wells' house? I entered, and Miss Wells motioned for us to go to the library, so we went to the library. And what did you find when you entered the library? Dr. Wells, a victim of a shot with gun blast on the ground. After you found Dr. Wells dead, what did you do? I performed an investigation. And did you conclude the cause of death? Yes, I did. And what did you, please step over to Plaintiff's Exhibit B for identification. And Plaintiff's Exhibit B. Under what fact did you base your conclusion? The fact that Dr. Wells was wearing his hunting clothes. He had an appointment at 12. The gun, the cleaning materials, and the brain tissue on the wall. And I found on the suicide note. And what did you do after your examination of Dr. Wells? I issued a certificate of death. Your Honor, I would like this to be marked as Plaintiff's Exhibit C for identification.
Your Honor, the counsel for.
Yes, you may.
Yes. Your Honor, you might also push that.
Sure. All right, y'all may proceed.
Thank you, Your Honor. Do you recognize Plaintiff's Exhibit C for identification? Yes, I do. What is it? This is the certificate of death I issued for Dr. Wells. Thank you. Your Honor, I would like Plaintiff's Exhibit C for identification to be entered in death.
All right, you may be introduced.
Thank you. Would you please read to the court what this Plaintiff's Exhibit C says the legal cause of death is? It says that Dr. Wells died from an accidental shotgun blast. And, are you familiar with Dr. Wells' practice? Yes, I am. And, what kind of practice was it? He had a good practice. What do you mean by good practice? It was extensive. He had many patients, and I often consulted him with some cases. Would you please tell us of any other relationships to Dr. Wells, other than that professional? He was a good friend of mine. And you said that you examined Dr. Wells twice yearly. Could you please tell us more what physical condition he was in? He was in great physical condition. He was 6 foot 2 inches, 200 pounds, 50 years old. Great condition for a man of his age. When did you last see Dr. Wells? The day before his death. What were you doing? I was running some errands, and I met with him in town. How did he seem at the time to you? He was in a good, cheerful mood, cracking jokes like he always was. Would you please tell us of Dr. Wells' reputation in the community? He was a good man, liked by lots of people in the community. He was very religious and moral. And was he on any religious board? Or he was on the school board and the vestry of the local Episcopal church. And would your knowing Dr. Wells affect your professional decisions? No, because I was trained in a way not to let personal matters get in my way. Thank you, Your Honor.
I want to cross-examine the witness. Yes, Your Honor.
Dr. Cohen, you said you found this screwdriver in the scene of death. What did you think would be possible for a man to, is it possible for a man to trigger a shotgun with a screwdriver? Is it possible?
Yes.
It is possible. How tall did you say Dr. Wells was?
6'2".
And which way was the gun fired in your opinion? Upwards, downwards?
Upwards.
Upwards. And where was the blood, the tissue located?
About 5 to 6 feet up on the outside wall.
5 to 6 feet?
Yes.
According to your deposition, Dr. Coleman, is this your deposition, Dr. Coleman?
Yes, it is.
Can you observe? Could you read that sentence for us, right?
It says it was about 5 feet up from the floor.
5 feet up from the floor.
Yes.
How would you explain this? A man, 6'2", and the shots fired upward. How would the tissue come to be 5 feet off the floor?
Well, I figured could have been kneeling or sitting on the floor.
Do you have any idea which position it could have been?
No, I can say just kneeling or sitting.
Good to say. Well, you said Dr. Wells had an extensive practice, is that correct?
Yes.
Well, hypothetically, would you consider total gross estate $55,000, a pickup truck, $1,700 in cash? Consider that an extent of the products of an extensive practice? Is that what you consider extensive?
Well, he, at the time, I guess, it's not huge, because he had lost $20,000 in the stock, but...
So you know about
But
losing
that's,
stock.
you know, he wasn't in that deep financial trouble with that much money.
You said he had an extensive practice, correct?
Yes.
You consider your opinion is that total gross estate of $45,000, a pickup truck, $1,700. Is that extensive to you? That's an extensive practice?
Objection, Your Honor. That's mere speculation.
Let's cross-examination. Overruled.
So, is that the products of an extensive medical practice? Just a pickup truck, $1,700 in cash, a state of $45,000.
Well, he's living pretty good. Better than some people I know.
And you call that extensive?
Compared to some people, it is.
Do you call that extensive for a doctor?
Pretty good.
Practice.
Yes, it's okay.
You said Wells was cheerful and happy on the 11th. Is that correct?
Yes, it is.
Did you see him at all on the 12th?
No, just that after, when I examined his body.
Did you talk to him at all on the 12th?
No, I didn't.
So you had no contact with Dr. Wells whatsoever on the 12th?
No.
So you don't know what he was like on the 12th, do you?
No.
It could change overnight, can't it?
I suppose.
Did you know Dr. Wells personally?
Yes, I did.
For how long have you known him?
Good many years.
You say you looked for a suicide note at the scene, is that correct?
Yes.
Why did you look for a note?
To see if there was one. See if
There's always, in a death such as this, there's always that possibility. There's a suicide note, isn't there? Always that slightest possibility there could be a suicide note. In a death such as this type.
I suppose.
That's why you looked for one, correct? So when you were looking for the note, there was a possibility there could have been a suicide note, wasn't there?
Yes, but it wasn't.
And so wouldn't it have been better for you, Dr. Cohen, if you found out, you thought it was an accident, but wouldn't it have been better for you even if you would have called for a coroner's inquest and got several unbiased opinions on this? Maybe they could have determined the position of the body and all this, and wouldn't it have been better for you to have called for a coroner's inquest? You knowing Dr. Wells personally, that you did.
Well, Miss Wells called me over at the time, so I just, and she asked for me to go over, so I went.
Well, couldn't you have called for a coroner's inquest a little later? Afterwards, and got 6 or 7 people to investigate this death? Wouldn't that have been the correct thing to do? Don't you think, Dr. Cohen, that would have been?
Well, I believe I have enough experience myself.
Would you like to see Mrs. Wells get the money anything? Would you like her to see this, get this double indemnity? Would you like that?
Objection, Your Honor. It's relevant to the fact.
We're establishing,
Do you have any relevance?
we're establishing that could affect this investigation.
I'll overrule it then.
Would you like to see Mrs. Wells get the double indemnity from the American Life Insurance Company?
Well, like I said, I was trained in a way that I don't let personal matters get my way.
But wasn't it hard for you when you were examining that dead body? Wasn't it hard for you to put it out of your mind that was Dr. Wells, good
No.
friend of yours? Wasn't hard. It wasn't hard for you to put that out of your mind.
Because I just told you, it surprised me, Dr. Holmes.
So you didn't call for a coroner's inquest. You thought it was the evidence of a close friend. And you did not know the position of the body when the gun was discharged, and you thought that was enough to allow something to such like an insurance company investigate. You thought that would be enough evidence to Dr. Holmes.
I couldn't understand what you said.
You thought that you being a close personal friend, for some reason you didn't call for a coroner's inquest. And you thought that your evidence would never be questioned.
Well, I figure I have enough experience. I don't see why anyone would have to question my
But
judgment.
if you had called for a coroner's inquest and they had found the same thing you did, wouldn't that just been more evidence for Mrs. Wells? It would, wouldn't it? If they would have found out it was an accident too?
I suppose so.
Or maybe you was afraid of the coroner's inquest to find out it was suicide, didn't you, Dr. Holmes? Is that what you were afraid of?
No.
And yet you did call for a coroner's inquest. No further questions, Your Honor.
You read the record?
Yes, Your Honor. At the time of your investigation, did you know about the insurance policy? No, I didn't. And, you stated that the shot was fired upward. What do you mean by upward? In this angle or straight up? In this angle, like 45 degrees. And, did Mr. Wells practice in an office building? Yes, he did. And did he own it? Yes. And, in this kind of case, isn't it a greater possibility that it was an accident?
Objection, Your Honor. Please go ahead.
Sustain the objection.
Thank you, Your Honor. Where was the county coroner at the time of the death? He was on vacation. Thank you, Your Honor.
Yeah. So you said the shot was fired up, is that correct?
Yes, I did.
Upward. You said what? You just said what? 45?
Not straight up, but
45 degrees? Is that what you
yeah,
said?
about like
45. So, how do you explain this? Him being where he was? In this position with a loaded gun, away from the chair. What's your theory of what he was doing on that?
well, I figured that he had his gun on the ground and a screwdriver, yes, and because he didn't want to get his stock certificate dirty, and he went and sat down and started taking his gun apart to clean it, except he didn't get that far. As soon as he picked up the gun, discharged.
And somehow the barrel of a loaded gun is pointed at Dr. Wilson's face. Somehow that happened.
He was looking down the barrel to see if the bullet was clean already, or if he needed
He
to
was
clean.
looking down a barrel that wasn't even broke. He was looking down a barrel like that. Could
Well,
you see much?
he could have been doing that, or just as he picked it up, to pick it up like this and pulling it up, it could have went and,
Couldn't see much to a gun that wasn't broke, could you?
well, he may not have been, he might have been picking it up.
So you think he could have been cleaning or working
About
on
to,
it?
yes.
About to work on cleaning.
Except he didn't get that far.
Did you notice any cleaning tissues in the room?
I saw the cleaning material, yes,
Where were they located at?
on the desk.
On the desk. So he possibly hadn't been heading to the kid, had he?
Probably not, because he was taking the gun apart to,
No further questions.
Anything else?
yes, Your Honor. Does the doctor just have to be looking down the barrel? Couldn't he be looking around it? Yes, he could. And, were there any indications that there was a suicide?
Objections, please.
Overruled.
Well, were there? No, because it looked more as an accident from he had his hunting clothes on, cleaning materials out, and a suicide note. And could the doctor reach the cleaning materials easily? Yes, I'm sure he could. And also, he said that he didn't want to get his stock certificates dirty. Was there anything else he didn't want to get dirty? The life insurance.
Objection, that's speculation.
I think so. I'll sustain the objection.
Thank you, Your Honor. Thank you.
You may sit down. Mrs. Plaintiff talk.
Plaintiff calls Mr. Dale Wells to stand.
See if I can stand as well.
Please state your name. Adele Wells. Dr. Sam Wells, your husband? Yes, he was. How long were you married? 24 years. Did something happen on February 12, 1985? Yes, that's the day I found Sam dead in the library of my home. And how did you come to find your husband? Well, I hurried back from my outing. He sent me to the truck for an appointment at 10, and when I entered the house, I called him as I always do. What happened? Well, he didn't answer me, and I became very worried, so I walked over to the library and knocked on the door and called to him, and he still didn't answer. And then what did you do? Well, I entered the library. What did you see in the library? I saw Sam lying on the floor. What was he wearing at the time? He was wearing his usual honey clothes and the brown jacket I gave him for Christmas. Can you please describe the library? Well, on his desk I noticed some cleaning materials and also some papers. Do you remember what those papers were? I believe they were stock certificates. And after you found your husband dead, what did you do? I ran over and felt his head and it was cold, so I knew Sam was dead. And then what did you do? I called Deputy Sheriff Clarence Williams and told him what had happened and requested that he come over and bring Dr. Cohen. Did they come? Yes. What did they do when they arrived? They went into the library to conduct their investigation. When did you last see your husband alive? That morning at breakfast. How did he seem? He was his usual self, cheerful, happy, like he always is. When was the last time you saw your husband before this? It was the night before. We had dinner together at 6:30 p.m. as usual. How did you seem then? He was in good spirits, cheerful, as always. Did you know of your husband's business or financial affairs? No, Sam always took good care of me and our financial affairs. He didn't want me to have to worry of those matters. Did you learn of anything after your husband's death? Yes, I found 3 life insurance policies. The American life happens to be the only one that won't pay me for accidental death. Your Honor, I'd like to have you
Hey, defense counsel says God.
What's your man?
Well, do you recognize the policy? Yes, it's the American life insurance policy. Can you please describe it? Well, the face value of this policy is $50,000, and if the death were accidental, it would be $100,000. And what did you do after you found the policy? I called the company and I gave it to Mr. Stevenson, and he claimed me $100,000 for Sam's accidental death. What happened? He didn't pay me. When was this policy taken out? November 2nd. Did you learn of anything else? Yes, I learned that the stock company that Sam had bought the gift of stock from failed. And when did this fail? Well, way after Sam bought the life insurance policy, I believe on January 26th. Your Honor, I ask Clarence to please come and take
All right, let's be introduced.
Did you tell the court what the value of your home is? It's $45,000, but it stands on $15,000 in our home in Florida. Can you tell us if there's any other assets? Well, we still have $30,000 left in our home, and $1,200 in the checking account, and $500 in the savings account. Thank you, Your Honor. That's all.
Okay.
Ms. Wells, you stated that when you returned home on one of your husband's death, that the door to his office was locked. Is that true? Did your husband usually lock the door to his office?
No, not unless he had some business to do with it.
What kind of business?
Well, usually when he was with a doctor or a patient,
Did he have a doctor or patient in the house with him that morning?
but at breakfast he told me he had some work to do with it.
But did you ever know your husband to lock the door when he didn't have a doctor or patient in the house?
When he wanted to be alone.
Now, I believe you have stated in your deposition. Do you remember your deposition in court?
Yes.
Now, didn't you state in your deposition that you never knew your husband locked the door unless he had a patient or a doctor?
Yes.
So it was strange that he had the door locked that morning without a patient or doctor, was it?
Kind of.
Miss Wells, you say your husband took care of all the financial affairs?
Yes.
Was your house mortgaged?
Yes.
Did you know about the house being mortgaged before your husband's death?
No.
Do you know of any major withdrawals made from your husband's bank account over the past year?
I thought he was dead. I thought I could check out money for the stock.
Did you know anything about this before your husband's death?
No.
Know anything about the stock transaction or the loss that he sustained from that before his death?
No.
Were you aware, Miss Wells, that your husband tried to borrow $6,000 on the day of his death?
No.
Did you think of any reason why he might have needed that money?
He just wanted to take care of his finances.
Well, being the administratrix of the estate of your husband, have any debts been revealed to you that would explain why he would need that money urgently?
No, nothing.
Therefore, your husband had many dealings that you don't know about, did you?
Yeah.
You read the record?
Yes, Your Honor. You said that Dr. Wells didn't let you worry about financial problems, isn't it?
Yes.
And isn't there a possibility that he was afraid you would walk in on him while he was reviewing his financial documents?
Yeah.
That's what it was.
All right, you may sit down. Okay, complaint.
Yes, Your Honor.
Who's the defense call?
Your Honor, the defense wishes to call Mr. James Stevens.
James Stevens, please. Were you sworn, Ms. Stevenson, when the rest of the witnesses were?
Mr. Stevenson, what is your occupation?
I'm general manager of the American Life Insurance Company.
How long have you been employed with American Life?
I've been employed with this company since 1974.
Do you have an area of specialization?
I supervise the claims department.
Did Dr. Samuel Wells purchase an insurance policy from your company?
Objection, Your Honor.
Wait, just a minute before you answer, let me get the objection. What's the grounds of your objection?
Leading question.
I don't know if any other way that question can be asked. I'm just thinking. Oh, a little bit.
Thank you.
Did Dr. Samuel Wells purchase a policy from American Life?
Yes, he did.
What type of policy did Dr. Wells purchase?
He purchased a 5-year term policy.
Do you know why Dr. Wells wanted to purchase additional insurance?
He was getting older, and he said he wanted sufficient protection to adequately provide for his wife in case anything should happen to him.
Is this policy a valid contract?
Yes, it is.
When was the policy issued?
I issued the policy to Dr. Wells on November 2nd, 1984.
Was this policy in effect at the time of Dr. Wells' death?
Yes, it was.
Who was the beneficiary of the policy?
This was Adele Wells.
When did you first learn of Dr. Wells' death?
On February 12th, 1985.
Why did your company refuse to pay Mrs. Wells' claim?
The claim was referred to our claims department for investigation, and our investigation revealed that his death was suicide. during our investigation, we
Objection, Your Honor. That's the narrative answer.
I think that's probably correct. You need to sustain the objection. You need to let the counsel ask you questions rather than go through a narrative.
Thank you, Your Honor.
You may proceed.
Why did your company refuse to pay Mrs. Wells' claim?
I had first-hand knowledge that Dr. Wells was in financial trouble, and also during our investigation, we revealed that Dr. Wells was being investigated by the Internal Revenue Service, and we also discovered that he had had a large stock transaction that fell through shortly before his death.
Would you please elaborate on your first-hand knowledge of Dr. Wells' financial condition?
On the afternoon of February 11th, 1985, he came into my office and wanted to borrow $6,000 on a life insurance policy.
Were you able to lend him the $6,000?
No, I was not.
Why not?
I had to tell him I couldn't lend him the money because term life insurance had no loan value.
Do you recall Dr. Wells' reaction?
He was desperate for the money. He had to have it by noon on February 12th.
Did you see the policy?
Yes, I did.
On February the 11th, one day prior to Dr. Wells' death, did you notice anything different about the policy itself?
No, I did not. It appeared the same as it had on the day I issued it to him.
When was the next time you saw the policy?
On February 18th, 1985, when Mrs. Wells made her claim.
Did you notice anything different about it, about the policy then?
Objection, Your Honor. That's the leading question.
I'll overrule that objection. Again, I think it's a proper form of the question. Go ahead.
Mr. Stevenson, at the time you received the policy from Mrs. Wells, did you notice anything different about the policy itself?
Yes, I did. There were 2 carat marks in the margin of the policy.
Did Mrs. Wells ever mention or refer to these carat marks at any time?
No, she did not.
Did she ever indicate to you that she made these marks?
No, she did.
Where did these carat marks appear?
They appeared next to clause 4 and clause 7, which deal with benefit in case of accidental death and suicide of insured.
Were these carat marks present on the original policy at the time the policy was issued?
No, they were not.
In your opinion, why are these carat marks significant?
We feel that Dr. Wells carefully considered the provisions of our policy and then took it on life.
What do you mean by carefully consider?
When we feel that someone who is reading over a policy carefully would sometimes place check marks on it.
You stated that this policy was a valid contract and it was in effect at the time of Dr. Wells' death. According to the terms of this policy, how much do you owe the beneficiary, Mrs. Adele Wells?
$650.
Thank you.
Any cross-examination?
Yes, Your Honor. You work for the American Life Insurance Company, do you not?
Yes, I did.
And you've been working for and paid by the American Life Insurance Company for the past 12 years?
That's correct.
Isn't it a fact that you issued Dr. Wells' policy?
Yes, I did.
And when was this?
On November 2nd, 1984.
Was this his only insurance or was it additional life insurance?
He said he wanted to purchase life insurance from my company. That was the only policy he purchased from me.
Was it additional though?
Not to my knowledge.
Was it normal for a man his age to take out life insurance?
Yes.
And did he pay all the premiums that he owed you?
Yes, he did.
Do people normally borrow off life insurance policies? Have people borrowed before?
They sometimes do.
Just answer yes or no, please.
Yes.
Do you usually take claims like this?
It depends on what.
Just answer the question.
Objection, Your Honor. She's harassing the witness.
Well, I think you need to allow him an opportunity to explain his answer if you like. So go ahead. Answer the yes or no first, and if you'd like to explain it, go ahead.
It depends on what we decide the claim is, and if the matter goes to litigation, what the court decides is whether we pay the claims or not.
Isn't it the fact that you didn't bring any carrot marks to the attention of Mrs. Wells?
I
You
didn't.
never asked her to put them there?
Yes.
You just assumed Dr. Wells put them there.
It seems only logical that
Well,
he
just please answer my question.
objection. She's harassing you.
I think that's proper cross-examination for her to demand that the witness answer his question. If you want to explain, you need to ask permission after you answer that.
Yes.
Truth is, you don't really know who put them there, do you? Not for a fact. That's all, Your Honor.
Any direct, redirect?
Mr. Stevenson, did Mrs. Wells ever mention or refer to these carrot marks at any time?
No, she did not.
She never indicated to you that she made the marks there herself. Is that correct?
Yes, it is.
So, wouldn't it be logical to assume that it would be almost impossible for anyone else to make those marks but Dr. Samuel Wells himself?
I would think so, yes.
Thank you.
Anything further?
Yes, Your Honor. Is it the fact that even though Mrs. Wells never indicated anything about the carrot marks, that she never indicated anything otherwise?
She knows that they were there.
Well,
She
will you
put them there.
please-
She would tell them.
We reject it and explain it. Just answer the question. Yes or no. Get called for a yes or no answer.
Repeat the question, please.
Isn't it the fact that though Mrs. Wells never mentioned the policy, the carrot marks on the policy, that she never said that she had not made any marks on the policy?
Yes, it's true.
Thank you, Your Honor.
Anybody?
Yes, Your Honor. Mr. Stevenson, if Mrs. Wells, this is hypothetical, if she had put the carrot marks on the policy, there would be no purpose in all of us being here today. Is that correct?
Objection, Your Honor. That's mere speculation of the witness.
Correct. Explain the objection.
Thank
Go
you.
ahead and answer that question.
Did Mrs. Wells ever refer to or mention the carrot marks to you at any time?
No, Your Honor, that's already on the record.
Stevenson, ask and answer.
No further questions.
Thank you.
Ready? Y'all do this with it. You may step down. Who's the defendant call?
Then we'd like to call Mr. William J. Burns.
William J. Burton?
Yes.
You sworn when the other witnesses were sworn?
Yes,
State your name.
William J. Burns.
What's your occupation, Mr. Burns?
I'm a certified public accountant with the Internal Revenue Service of Lexington, Kentucky.
And what's your position with the IRS?
Chief Auditing Investigation Division.
How long have you held this position?
5 years.
Your Honor, I'd like to answer that. Mr. Burns be recognized as an expert
In what field?
in the field of accounting and income tax. All of these.
You don't have any objections?
Your Honor, wouldn't that be irrelevant to whether or not he killed himself or it was an accident?
Well, I don't know. I just don't know if any recognized experts. We'll just have to see if the president, I'll reserve the ruling on that if it becomes necessary. Not sure I recognize, understand an expert in audit.
When did you first become familiar with the name Samuel Wells?
In August 1984 investigation of our department, my head, the head of my department, he informed me to conduct an investigation
What was the nature of this investigation?
to determine whether doctors in Lexington area were submitting tax reports on the cash fee payment.
How was Dr. Wells involved with this?
In 1983 and the first half of 1984, Dr. Wells failed to file any cash fee payments whatsoever, whereas in 1982, he listed in excess of $15,000 and paid taxes on that amount.
So you thought he owed money?
Yes, he did.
Did the Internal Revenue Service make an estimate?
Yes, we did.
How much money?
We estimated his length at $5,000 to $10,000.
Was Dr. Wells informed of this investigation?
Yes, he was.
When?
I called Dr. Wells for the first time on September 25th of 1984.
And what was his reaction to this?
Dr. Wells, after I told him of the matter, he said he was trying to clear up any oversight on his part.
Did he do that?
No, he did not.
Then what happened?
After not hearing from Dr. Wells in 2 months, I called him back on November 15th and informed him that I would be in the Lexington office on February 15th, 1985, and that he was to meet me there. And if he did not, I would have to contact the U.S. Attorney.
And what was Dr. Wells' reaction this time?
He pleaded for more time, but I insisted. He finally agreed to meet me there.
And once again, could you tell us when you began this investigation of Dr. Wells?
In August of 1984,
And he was first contacted when?
I contacted him for the first time on September 25th, 84,
And he was given how long to clear the matter up?
until February 15th, 85.
Almost 5 months.
Yes.
Yes, Your Honor. Examine.
Isn't it a fact that the reason for your investigation was to determine whether or not doctors in the Lexington area owed any money in taxes?
Yes, that's right.
Isn't it a fact you were looking to see which doctors were not submitting lists on payments made in cash?
That's right.
Isn't it a fact you didn't know which doctors were not submitting these lists?
We had a good idea.
But then why would, please answer the question. Did you or didn't you know which doctors weren't submitting these lists?
Not exactly, no.
Isn't-
Move approach me.
Yes, Mr. Brown.
Doctors were not submitting these lists on payments made in cash. Thank you. Isn't it a fact $5,000 to $10,000 you said Dr. Wells supposedly owed was a mere estimate?
An educated estimate.
Please answer the question. If it calls for a yes or no answer, just answer yes or no.
Objection, Your Honor. Please go ahead.
If you have a problem with the witness's answer, you need to address your objection to me, not tell the witness. But I will instruct the witness. This answers question. If you then want to explain, yes, you can ask permission to me.
Isn't it a fact $5,000 to $10,000 you say Mr. Wells supposedly owed was the estimate?
Yes.
Isn't it a fact that you have no proof that Dr. Wells was delinquent in paying his taxes, and the reason you called him was to look over his records?
Yes, that's correct.
Isn't it a fact you were investigating Dr. Wells because he wasn't submitting a list of payments made in cash? But I asked you, if he didn't receive any payments, would he be able to submit this list?
No, he wouldn't.
Isn't it a fact that most medical bills are paid by insurance companies and by personal checks?
Yes, that's right.
Isn't it a fact your meeting was not till 3 days after Dr. Wells' death?
Correct.
Isn't it a fact Dr. Wells had eventually agreed to this meeting?
Yes, he did.
And how long did you give him to come up with this money in the very beginning when you started investigating?
I did not.
10 months? Was it 10 months? 9 months? 6 months? you must understand my question. Between the time you started investigating and the time you're meeting, and between the time of your meeting, how long was it?
Almost 5 months.
And are you trying to tell us that you gave him 5 months to come up with this money and for you to start your investigation on him? Is that what you're saying?
Yes.
Okay. Did he ever fail to give you reports on cash payment? Has he in the past?
No, no.
Thank you. Thank you, Your Honor.
Are you ready? Mr. Burns, you stated that you gave Dr. Wells 5 months to clear up his problem. If Dr. Wells had quit taking cash as payment, how long would it take him to tell you that on the phone?
A matter of seconds.
How difficult is it for a taxpayer to clear up an innocent mistake?
No problem at all.
Could you please tell the court why you don't have an exact figure on Dr. Wells' delinquency?
Because Dr. Wells failed to cooperate with us.
Thank you.
No further questions, Your Honor.
Now, you missed up then. Who do you call?
This is what call Miss Norma Crowe.
Norma Crowe. So you were sworn when the other witnesses were sworn, were you not? This one has the radar.
Please state your name and occupation.
Norma Crowe, and I'm a stockbroker.
Are you experienced in stock transactions?
Objection, Your Honor. That question is leading.
I don't think so. I think that's a proper foundation question.
Thank you.
Overruled objection.
Are you experienced in stock transactions?
Yes, I am.
For a long time?
Yes.
Do you advise people on their stock transactions on a regular basis?
Yes, I did.
I'd like the court to recognize her as an expert in stock transactions.
Well, I'm not sure there is such an expert, but,
Just for the purpose of this question.
all right, we'll see.
Okay. Did you know Dr. Wells?
Yes, I did.
How did you know?
He was a client of mine. He'd be my physician. I know him since a child.
Were you his broker?
Yes, I was.
When was his last transaction?
August 8th of 1984.
Please explain this transaction.
He purchased 1,000 shares of Ghetto Company stock, $20 a share.
And how much money would this be?
$20,000.
Based on your training, was this a wise purchase?
No, it was not.
Did you tell him this?
Yes, I did.
Did he buy it anyway?
Yes.
Why?
He needed the money. He was in a bad financial squeeze.
When was your last contact?
The morning of his death, around 9 a.m.
And what was this contact?
He phoned me.
Did you talk to him often on the phone?
Yes, I did.
Did you know the sound of his voice?
Yes.
Was there anything unusual about Dr. Wells at this time?
Yes, there was. He was kind of really quiet and his voice was terribly shaky.
Why did he call you?
He was interested in borrowing $6,000. He needed it by noon.
Do you know why he needed $6,000?
No, I did not.
Do you know why he needed this money by noon?
No.
When you told, did you loan him the money?
No, I didn't. I would like to have, but I couldn't raise that amount of money in 3 hours.
When you told him that you just couldn't raise the money, what did he say to you?
Objection, Your Honor. That question will elicit hearsay.
It's directly to the state of mind of what you tried for instead of the state of mind exception.
All right, that's a recognized exception to the hearsay rule. I'll overrule the objection.
Thank you, Your Honor.
When you told him you could not give him money, what did he say to you?
He said, Norma, I'm desperate. I don't know what to do. Can't tell you why I need the money, but I am desperate.
And what time was this that Dr. Wells said he was desperate?
It was shortly after 9 a.m.
Was this the end of your conversation?
No, it was not.
What else was talked about?
Near the end of our discussion, we discussed the hunting trip that Dr. Wells had planned with Clarence Williams that afternoon as well.
conversation ended in this way.
Yes, it most certainly was. It did not relate at all to any of the previous conversations. Thank you.
Any cross-examination?
Yes, Your Honor. Isn't it true that Dr. Wells has borrowed money from you in the past? Yes, it is. And isn't it true that Dr. Wells always pays it back? Yes, that's correct. And yes or no, did Dr. Wells owe you a cent at the time of his death? Yes, no. And referring to the phone call, isn't it true that Dr. Wells was going to look for the money that he did elsewhere? He had already tried to apply for something somewhere else. But didn't he say that he was going to look for it somewhere else? He stated that he could not receive money from the bank because he already had a mortgage on his house. My question is, is it true that he was going, he said he was going to look for the money elsewhere? I have to say something with you. That's all you want to know.
Can you redirect?
Do you know of any other way that Dr. Wells had tried to get the money?
Yes, he tried to borrow from the bank, but he had a mortgage on his house and he couldn't. And he also tried to borrow on his insurance policy he had that he was trying to make.
Thank you.
Anything further?
No, Your Honor.
All right. Any rebuttal? All right. Okay, at this stage, ladies and gentlemen, now we will be turning this matter over to the jury. And I will first read your instructions. As you know, it's your duty as jurors to determine facts of the case. And based on the witness testimony from the witness, not from anything that the attorneys have said or will say in their closing argument. It is my duty as a judge to make rulings on the procedures that we will have and ensure a fair and orderly trial. And secondly, I must make rulings of law. And I also must give you the instructions that you'll be guided by, basically the law of the case in which to go. One thing I might point out that it is the duty of the attorneys to make objections if they feel one is taking place in the proceeding. And you're not to take anything by either their objections or my rulings. Those relate merely to matters of procedure rather than substance. These are the instructions that you'll be guided by in rendering the verdict. You need to choose the appropriate one that represents your verdict and have the foreman sign. This lady here in the blue be the forewoman of the jury. Right? Now, we, the jury number one, find for the plaintiff the sum of $50,000 in face value of the life insurance policy. You find this if you're unable to feel that neither, we are unable to find that he caused his death by suicide. And also that you're unable to find that it was accidental. In other words, each side has a responsibility and a burden of the proof. The burden on the plaintiff was to show that it was accidental. And if they failed to meet that burden, then you would fine for the defendant on that issue, in effect, and award. Well, if you find, you have to look at both sides. And the plaintiff's burden was to show that it was accidental. If they met that burden, you would award $100,000. It's the defendant's burden of proof to show that it was suicide. And if you find that they did show suicide, you can't find that it was accidental and suicide. So if you believe that they satisfied their burden and have shown beyond by preponderance of the evidence, that means over half, more likely than not, that it was suicide, then you would find under number 2 and find for the insured, find that he committed suicide and award only $650. Now, if you find neither way, you find that neither is satisfied the burden of proof, then you would award the $50,000. You feel that the plaintiffs have awarded that satisfied the burden of proof. You feel that it's more likely than not, based on this evidence, that it was accidental, you would award $100,000. So depending on whether you believe one side or the other, or you believe neither, or you have insufficient evidence with to believe it happened one way or the other, then you would find the court. All right? At this time, it is the defendant has an opportunity to make a closing argument to the jury. If y'all wish to make it.
Rule change.
A rule change. You want to come around to that? They should be in order for the first claim. Okay. So, we will allow then the plaintiff.
Your Honor, counsel, and members of the jury. You have just heard the case of Mrs. Adele Wells against American Life Insurance Company. There are two sides to every story, and this one is no exception. The defense has told you their part of the story, and they told it well. Mr. Crow, one of the defense's witnesses, said that the doctor tried to borrow $6,000, and that the stock the doctor had bought went bankrupt. But remember, at the close of his conversation the doctor had with Mrs. Crow, he said he'd look elsewhere for his money. The doctor has always repaid the money he has borrowed from Mrs. Crow. Mr. Burns said the doctor was under investigation by the IRS because he owed money. But note, the meeting to determine what amount, if any, the doctor owed was not until 3 days after the doctor's death. And of course, Mr. Stevenson, the agent who sold the policy to the doctor, said that the doctor tried to borrow on the policy. But note that when the insurance policy was taken out, there was no investigation. He was not in financial problems. And in fact, he had $20,000 in stock then, which was still a solid asset. Now the defense tries to piece together from those few facts that the doctor tried to commit suicide. They're totally incorrect. The defense has tried to suggest that Dr. Wells needed money so bad that he killed himself. But look at the evidence about the doctor's assets. The doctor had a good practice. His house was valued at $45,000. Even though he did use the house as collateral for $15,000, he still had $30,000 worth freely with. Also, at the time of his death, he had in cash $1,700. No, he was not in such a desperate need to kill himself. The defense further suggests that Dr. Wells was in trouble with the IRS. Hardly so, as the testimony of Mr. Burns, the IRS agent, states that his investigation was not exactly centered on the doctor. As a whole, it was a general investigation of the whole Lexington area. And remember, the meeting to determine if amount or any the doctor owed was not until 3 days after his death. What I'm trying to say is, the doctor might have not owed any money at all. And reviewing again, Mr. Stevenson, the life insurance agent who sold the policy to the doctor. He stated that it was normal for a man of the doctor's age to take out such a policy as he did. And he said the company usually pays these policies, but they didn't this time. The company says they conducted an investigation, and they determined it was suicide. But how can this investigation be considered complete? They didn't even ask the coroner's conclusion on the cause of death. See, Mrs. Wells, the late Dr. Wells' wife, has always lived in a comfortable, not extravagant lifestyle. She was never faced with problems such as money matters. Excuse me. The doctor loved his wife too much to let her be worried over financial problems. And it was out of this act of love that the doctor took out that insurance policy. He thought if an incident should occur, such as his accidental death, that his wife would be protected. He was wrong. The insurance company doesn't want to pay the policy, so they're making Mrs. Wells face all the problems she never had to face before. It is their actions that has brought Mrs. Wells to court before you, ladies and gentlemen, today. Mrs. Wells asked that you render to the amount under the, excuse me. Mrs. Wells, excuse me. To ask that you render her the amount under the policy for accidental death, which is $100,000. She asked that you base your conclusion on the evidence that I'm about to go over. But she believes if you cannot find $100,000 for her, She asked that you, in the alternative note, award her the face amount of the policy, which is $50,000, because the evidence is clearly inefficient to prove suicide. Now, the evidence that justifies our request for $100,000 is as follows. On February 12, 1985, Mrs. Wells came downstairs to see Dr. Wells seated in the kitchen. After a brief conversation, the doctor went into the library to review a few financial documents. After looking over those documents, he got out his gun and was going to clean it. He set the cleaning materials on the corner of his desk where he could easily reach it. He then retrieved a screwdriver to dismantle the gun. As he bent over to pick up the gun, it discharged accidentally. This was a tragic accident that took the doctor's life. The facts and proof supporting this are that the doctor was wearing his hunting clothes, there were some cleaning materials on the desk, and beside his body was lying his faulty shotgun. He had a hunting appointment at noon, and then he also had an appointment at 10 o'clock, possibly to get money, as he indicated in his phone conversation with Mrs. Crow. In the deputy sheriff's testimony, we proved that this gun was in fact faulty. The deputy didn't guess the gun was faulty. He was involved in an incident in which the gun proved to be faulty. Well, I leave you on this note. Be fair and use your best judgment, and we'll be sure to come with the correct decision, which is to award Mrs. Wells the amount under accidental death, $100,000. Leave this decision in your very capable hands. Thank you.
Well, let's make a closing statement on what happened then.
The police court, attorneys for the plaintiff, and ladies and gentlemen of the jury, I, Marshall Stewart, would like to sum up for you now in the case of the defense. You've heard what the plaintiff had to say. I plan to tell you something extremely different. I would like to paint for you a picture of a man who was desperate. This man is Dr. Sam Wells. We have proven that Dr. Wells owed the IRS up to $10,000. We have also proven that he lost $20,000 in an unadvised, high-risk stock purchase. Dr. Wells had tried to remedy these financial problems. He tried to borrow from the bank, but had no luck. He tried to borrow his insurance policy, but he had not had it long enough. He finally called Miss Norma Crow and asked to borrow $6,000, but Norma could not raise the money. We have proven that he was definitely in deep financial trouble. Furthermore, he told no one of all his problems. He bore this tremendous burden alone. There was no way out, except the easy way out, suicide. On the morning of February 12, 1985, Sam Wells, having little to say to his wife, locked himself in his library. The only other person who talked to Dr. Wells on this fateful day was Miss Norma Crow. Miss Crow has testified that Dr. Wells was frightened, shaken, in dire need of money, and desperate. Only a few minutes later, he was dead, a victim of his own stressful life. Could you possibly think this an accident? The thought is inconceivable. Dr. Wells was an avid and expert hunter. Would an expert hunter lock himself up to clean a gun? Would an expert hunter point a loaded gun at his head while working on it with a screwdriver? No, of course not. But both Deputy Williams and Dr. Cohen have testified that a screwdriver could possibly be used to trigger a gun. Dr. Wells' suicide had been planned for months. The alibis were in place. Everyone was told of his alleged hunting trip. The timing was perfect and essential. Has it occurred to you that Dr. Wells' appointment with Mr. Burns was scheduled for February 15th? And yet, Wells was desperate for the money by noon on the 12th. Noon on the 12th. Surely a hunting trip does not cost $6,000. As I said, the alibis were in place. The timing was perfect. On the subject of the safety. Now you have to understand, if the safety had been on, this would prove it was an accident. If it was off, this would mean that someone pushed it off and wanted the gun to fire. It would almost prove the case of the plaintiff if the safety had been on. Yet Deputy Williams doesn't remember. He can only say, I don't know. Dr. Durian did look for a suicide note, but he found none. Dr. Cohen and Mrs. Wells also looked for a suicide note and found none. Would a person trying to defraud an insurance company leave a suicide note explaining this? No, a suicide note in its normal sense was not present. But there, lying on his desk, lay the root of all of Dr. Wells' problems. Those worthless stock certificates were a message themselves. As you know, Mrs. Wells testified that her husband owned 2 other insurance policies in addition to the American Life policy. He had owned these policies for approximately 24 years. Can you think of any reason why Dr. Wells, a man in bad financial shape, would purchase new policies after all these years? This policy just so happened to be a policy which paid $100,000 in case of accidental death. Can you think of any reason for this? Perhaps Dr. Wells was expecting an accident. And yet, with all of the evidence proving Dr. Wells' suicide, there was one simple fact that clearly proves our point. Upon the insurance policy in question are 2 vital pieces of evidence. Why would Dr. Wells have placed check marks next to the accidental death and suicide clauses of an insurance policy that pays $100,000 in event of accidental death, unless he had planned to create such an accident? Dr. Wells was informed of the IRS investigation on September 25th, 1984. In this investigation, the IRS estimated Dr. Wells' delinquency at $5,000 to $10,000. It has been brought to your attention that $5,000 to $10,000 is not such a large amount of money to a doctor with an extensive practice. And it doesn't take a practicing physician long to earn this kind of money. It's true that Dr. Wells had $20,000 in his bank account on August 8, 1984, nearly 2 months before he received the first call from the IRS. He withdrew that money and threw it into a high-risk stock against his broker's advice. He was that desperate, wanting to make a killing, long before he received the call from Mr. Burns. This is exactly the reason you should question Dr. Wells' financial status. No one knows about all of his dealings. I ask you, the jury, why was Dr. Wells so desperate for money? I would like to summarize the facts for you. Dr. Wells was a desperate man, a man in deep financial trouble. Dr. Wells was an experienced hunter, but on the morning of his widely publicized hunting trip, this experienced hunter locked himself in his library with a loaded gun and a screwdriver. He never came out. The 2 men investigating the case were experts, yet they overlooked pertinent details of the case, and both men were good friends of Dr. and Mrs. Wells. Ladies and gentlemen of the jury, you have heard our closing statement. I am sure that after you have considered all the evidence and all the testimony, that you will find that we have presented due proof of breach of contract and rule in favor of the defense and award Mrs. Wells only the premium of $650. Thank you.
Sheriff, will you come around? I swear you'll keep these jurors together, suffer no person to speak or communicate with them until they finish the verdict. Ladies and gentlemen, if you go with the sheriff and let's go with the verdict.
Your Honor,
Yes.
now approach the bench.
Yes, that's both.
Thank you.
Give us that.
Okay, y'all want to, before just now, I didn't know which was Green County and which wasn't, but I think the defendants are Green County. Well, after a rather difficult decision here, but I'm going to award the, I don't need to keep you on the space is off. I'm going to award mine that Green County is the winner. A couple of things I want to point out. One, just a general nature. Both sides and all the participants, and I really mean all the participants, I think did better than the average young lawyer that appears in court. Some of you all probably approach some of the better ones, the ones that were least nervous, I guess you might say, approach some of the better attorneys that appear in that court. None of you, I guess, are quite Frank Haddad or Melvin Belli yet, but you certainly show potential for that. But now maybe so specifically, starting kind of going over this, in terms of the opening statements, probably the part that needs the most work on maybe is in terms of it speaking too fast. That probably hurt the plaintiff a little bit kind of throughout it, is that you spoke a little too fast. You need to slow down. It's hard for me to actually follow you sometimes, speaking too fast. But and that's a common trait. I did it when I was practicing law, and I was nervous too. Most good lawyers, I think, are nervous when you have a trial. But that's the reason I decided to become a judge. Because judges don't have to worry about it so much. It's a lot easier on your nerves to be a judge. But you got to be a lawyer first if you're going to be a judge. So anyway, the direct examinations.
Ready.
Is that yours ready? All right. Well, it'll come on back in. We might as well be here the rest of it. Form over there. You got the verdict?
I gave it.
You gave it. All right, you all felt that both sides failed to meet the burden of proof and therefore awarded the plaintiff $50,000. Is that correct? Do you all have any questions to ask? Do you all know this jury? In any event, I thought they were lying here before it is. Going through the other parts of it, the direct examinations I thought were excellent. One of the main things that you've got to know about, main thing to know when you're doing direct examination is to be to the point, to ask simple, concise questions, and don't ask too many questions. And I think that both sides did an excellent job about that. One of the problems with it is that you probably, in your direct and cross-examination, you ignored the jury a little bit. Some of you did, and most of you did, really. And they're the people who you're really trying to convince, although you really are me too, and you all ignore me some. But you should sort of make sure that you're backward. You're almost directing your questions, because it's hard to hear you. It's hard for me to hear sometimes when you have your back to me. By the same token, it would be hard for the jury. All the witnesses, for example, should talk to the jury. In this case, maybe you ought to talk to me some too, since my decision is maybe more important than the jury. But nevertheless, you should really direct your answers back to either the judge or the jury, not so much as it is to the person who's asking questions. I know that's unusual. You usually answer the person who's talking to you. But in a trial situation, it shouldn't be a matter of dialogue. You know, sometimes the witness and the attorney would get into a dialogue, and the jury and I might as well not be here. So, but in terms of the questions being concise, proper, good questions in order to get the information you sought, I really don't know. In some of those examinations, I don't think there could have been much improvement by anybody. You know, of course, it helped that you only had 7 minutes to do it in, but you did a good job there. I couldn't detect anybody running over, certainly not over a minute or two. So one of the things about exhibits in direct examination is for an exhibit to really have its most effect on the jury is, of course, let them see it. So all of you just kind of lay the exhibits up here on the bench where they remain, and you should. The best thing to do is to ask permission, once it's been introduced, is to ask permission to pass the exhibit to the jury. And the best time to do that is when you're finished, then give it to the jury so that they're paying attention to it while your opponent is doing cross-examination and they won't hear what they're talking about. So, but it is good. In other words, if you want to make a big point, then you wouldn't want to pass it to them so they are watching, looking at the exhibit. So wait till you're finished, and when you're finished, I think it's best to then ask permission to permit the jury to pass to the jury the exhibit that has been lawfully introduced. But those are about the only things. Some of you were nervous, and that's part of it, and some were less nervous, and it just makes a better presentation. If you are. The area about phrasing questions and exhibiting a clear understanding of the proper procedures, I think both sides showed a very good understanding of this. I think you've had some previous trials, so I guess you all know it pretty well now. The closing arguments were both very good. Probably one of the reasons the defendant scored a little higher was the fact that there was some breakup in the delivery, some real arguments. In other words, this is a time when you're not bound by any rules of evidence. You're not bound by, you're just barely bound by the truth. And for the most part, attorneys take a little liberties with that. But this is your chance, your one chance to get up and really make a persuasive argument to the jury. You're not really bound by many rules and regulations. And so you ought to use that, and by the same token, you don't have to be too impassioned. I've had prosecutors when I was defending that would cry, when they're making their closing statement. And it's just very effective. Sometimes if you don't know what they're doing. So, maybe a little tear here and there by the plaintiff's attorney may have helped, rather than being too matter of fact, because that is the time when you can really have some liberty to get your point across. But both of them were excellent, better than average. But now, as to the witnesses, they all ranked very high. Some were better than others, but there were no poor witnesses. They were all at least good. Most witnesses, at least average, better than good, and there were only a couple places where I rated a witness, an aspect of a witness, as good. Again, the witness needs to speak to the jury or the judge if you feel that that's more important than this particular thing. You need to speak to them, maybe show a little more emotion. For example, the plaintiff, maybe if you could have a little tear in your eye when you're talking about poor Sam, departed Sam, it might help. But not to say that the widow she was a good witness and received a high score. And she was somewhat reserved, at least was not joking. And so you need to kind of watch your effect. But I thought it was very good. For example, the stockbroker did a good job, I thought, as a witness. In terms of just really speaking up and being relaxed and just showing a little more emotion. You need to show, most witnesses have some emotional aspect to it. And if you don't show some emotion, that generally has some effect. But the witness is very good. Both teams were very courteous and observed the courtroom decorum and whatnot. Possibly everyone needs to speak, or most need to speak loud. There were several who I had trouble hearing sometimes. So, and I'm one, I'm in a pretty good place to hear up here. So, you do maybe need to speak a little louder, but in terms of courteousness, I think that is part of the plaintiff. Acknowledge the court and thank the court on its rulings, whether they were favorable or unfavorable. When you lose, and y'all did a good job of cussing or doing anything else, and you lost the ruling here, you got to go on and realize, for example, that the judge has to make these rulings spontaneously, that our attention span sometimes wanders, it never fails if I'm going to daydream during a trial that somebody's going to object at that very moment. And so a lot of times when I'm having to rule, I don't even know what they're talking about. And so I just have to kind of pick it up when I ask for the attorneys to, generally when I ask for the reasons, it's not that I really need a reason, but I need to have some idea about what we're talking about. So it's good to let the judge know, give him a little background about his objection, because you will save him some embarrassment and prevent the judge from having to go back and say, well, now what was the question? But most of the time, judges are attentive and will know that they will make mistakes. Just like a referee in a ball game, even if they're good referees, they're going to make some bad calls during the game because it happens so fast. So if you lose a ruling, just the best thing you can do is just act like it never happened. And I think both sides did a good job in that respect. There were some objections some good objections that could have been made that weren't. I'm trying to think. One time I almost made it once, but the judge has to remember not to get involved in the trial. But one of the attorneys didn't ask a question. I started to ask her, "Is that a question?" You all just let it slide. But you got to watch attorneys when they're making questions, going over and making speeches. The only time an attorney can make an argument or a speech to the jury is in closing argument. And there was at least one time, maybe more, where the attorneys put in a little statement there that wasn't a question. And the jury, both the witness and the other side let it go. So you don't want to make too many objections, but you do need to, some of the objections, were not really too good. Particularly, you got to watch leading questions. I mean, there's only some questions have only one way of asking. And just because it may suggest to answer their background questions, qualification of a witness, background material, those are questions that may have some leading aspects, but they're not improper because the fact that it's the only way you can ask them. So, but by the same token, there were some good objectionable material that both sides let go by. So you need to kind of watch that a little closer. Okay, anybody have any questions about that? Basically, thank you all very much. I enjoyed it. Y'all did a good job.